Welcome, everyone. Welcome to this Saturday, November 7th, show of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Kristen Walters. We're running a little rough here. We don't have the backup with Desert, but there's some good news. Desert got into a place, and he should be maybe set up for next weekend. So we'll have the backup, and things will run a little bit smoother here. So this is the show that everybody's been waiting for. I sent out some emails there. I hope everybody is as excited as I am that this Saturday show on Money, Banking, and Trust by Moving Titles and Commerce will be a monumental occurrence. So I hope you called all your friends. Today's the official announcement of a new cutting-edge technology as a new remedy utilizing Moving Titles and Commerce platform, which is basically everything we've been talking about since I've been on this show for the last year and a half. And I am formally announcing, and could I have that drum roll, please? NTT, which is New Trust Technology. So NTT as New Trust Technology is going to revolutionize the commercial remedy industry by concentrating on the core problem today, which is really no knowledge, no understanding of a secret relationship hiding at the core, an invisible trust. NTT is going to be earth-shattering. New trust technology will reveal the trust relationship that is well hidden, being wrapped by a colorable contract, operating under UCC and commerce as a debtor-creditor law, whereby you are construed to owe a debt for a secondary unconscionable contract that has already been paid. And you just had no knowledge, no understanding of that secret trust relationship and how to make it function for you as it does for them through expressing the trust so that it's really not construed. So NTT is going to be like a hammer. It's going to be groundbreaking. And NTT will focus like a magnifying glass, crystal clear. And NTT will be a hot laser like the sun melting the problem. So master new trust technology, and with NTT, you'll become the master and not the slave. So you're here all in anticipation for that grand opening, and I thank you for joining me again. But take notice and agreement with that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. And you will not use any of this information for making a legal decision or performing a legal procedure that is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Kristen Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Kristen Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons to communications between the parties. By reading or using this information, you acknowledge and agree that you are not a client of Kristen Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Kristen Walters' discretion. Thank you for your understanding. So as I said in the emails, that new trust technology, NTT, will revolutionize the commercial remedy industry. Focusing on the approach will be the trust relationships and trust alone. And NTT as new trust technology will view everything as a trust first and not as a construed debtor-creditor relationship 14th Amendment citizen under UCC, Law, Merchant, and Commerce. Instead of talking or just mentioning a trust, say, for example, House Joint Resolution 192, or that a straw man Social Security number account, trust account exists. It is learning through NTT to express the trust, act and function as a trust all the time in the public. NTT, as new trust technology, it's how to first express the trust so it is not construed through precatory words or weak wording. And more importantly, once expressed, how to administer the duties and actions of an officer of NTT trust relationship, with the key focus on rule of signatures and rule of forms. So I hope that this has whetted your appetite, and why you're here tonight is really not to argue the fact that trust exists. I'm really gearing this show towards people who already have that belief, and I want people to understand that it's the trust that's the center of the core, and if you don't believe that, how can you and I walk together in the same direction? And I would suggest that if you're not willing to listen to what I have to say instead of you telling me what you think, then you need to join another call. So that is up front. We're going to stick on topic tonight, and I'm not diverging from the topic. I'm not getting into any kind of arguments tonight whether a trust exists or not. I'm going to the assumption it does, and if you don't agree with me, then we have nothing in common. So over the past months, for the year and a half, we've been talking about creating and claiming and moving titles, which is really the platform which NTT, New Trust Technology, is riding on. And if you've missed all the past shows and you've just come in now, you're in a graduate class and you may be in the dark, and you need to go back and somehow get a hold of the past shows and get up to speed, because if you don't know how to create a title, if you don't know how to claim a title, and you don't know how to move a title, then you have no idea what we're talking about, because that's the basics first that this new trust technology is resting on. So we're utilizing, in commerce, using except for value, UCC, and GSA forms and IRS forms in expressing the trust. So it's all about expressing the trust. So will you join me? For our battle is truth, justice, and the American way in preventing our beloved America from being completely swallowed up by the United States. Now think about that statement. Understand and gain knowledge so that you may realize what is really going on under our very noses and not perish. And I would compare that to Romans chapter 12, verses 1 and 2. So all the definitions that I'm using, I'm taking out of Black's Law 8th edition, unless noted. And emphases are all mine. So why they have done what has been done really comes down to the definition of legal fiction out of Black's Law. And the definition of legal fiction is the assumption that something is true even though it may be untrue, made especially in judicial reasoning to alter how a legal rule operates. Specifically, a device by which a legal rule or institution, a trust, is diverted from its original purpose to accomplish indirectly some other objective. The constructive trust, or the SDK trust strawman Social Security account, is an example of a legal fiction. That's 1901, Henry S. Maine wrote, quote, I employ the legal fiction as to signify any assumption which conceals or affects to conceal the fact that the rule of law has undergone alteration, its letter remaining unchanged, its operation being modified. It is not difficult to understand why fictions in all their forms are particularly congenial to the infancy of society. They satisfy the desire for improvement, which is not quite wanting, at the same time that they did not offend the superstitious disrelish for change, which is always present. 1933, Morris R. Cohen wrote, quote, a legal fiction is the mask that progress must wear to pass the faithful but bleary-eyed watchers of our ancient legal treasures. But though legal fictions are useful in thus mitigating or absorbing the shock of innovation, or it could be your innovation, they work havoc in the form of intellectual confusion. So now I want to jump to Black's Law definition, privity of contract, where privity means the connection or relationship between two parties, each having a legal recognized interest in the same subject matter, such as a transaction, a proceeding, or a court case, or a piece of property, estate trust. Mutual of interest, privity of contracts. The relationship between the parties to a contract, allowing them to sue each other, but preventing a third party from doing so. The requirement of privity has been relaxed under normal laws, modern laws, and doctrines of implied warranties. Now that's trusts. And strict liability, which allows a third-party beneficiary, that's a trust term, or other foreseeable user, that's also a trust term, to sue the seller of a defective product. So would that defective product be a non-performing slave, aka straw man birth defect, lack of performance? So continuing on, to many students, and these are the infancy of society, and practitioners, now these are the blurry-eyed watchers, of the common law, privity of contract became a fetish, or in other words, you're supposed to agree or have knowledge of a contract to be liable student practitioners. Continue on. As such, so as not to offend the superstitious relish for change, in other words, this change, continue on, it operated to deprive many a claimant of a remedy in cases where, according to the Moors, now the Moors are the dead with no vision and cannot see, the Moors of the time, the claim was just, and has been made many learned men, or the bleary-eyed watchers, believe that a choose an action, a court action, could not be assigned. Even now it is gravely asserted that man cannot be made the debtor of another against his will, in other words, by common law disrelished. So, but the common law has been gradually influenced by equity, in other words, through trust, where no disclosure need be given, and a trust wrapped in a color of common law contracts. So, and by the law merchant, that would be the UCC, so that by the assignment, that's a UCC 3 filing, a debtor could become bound, and that's by the act or actions of silence. Continue on, to pay a perfect stranger to himself, and even if he had no privity of knowledge. Continuing on, although until the legislature stepped in, and what did they do? Well, they came in with House Joint Resolution 192, Public Law 7310, giving you a remedy, again, through a trust treaty relationship. So the common law courts characteristically made use of fiction or trust and pretended that they were not doing that which they were really doing. Bingo. That's what they do not want you to know. That's William R. Anson, Principles of Law of Contracts, 335, and Arthur L. Corbin, Third American Edition, 1919. And that's right out of Black's Law, 8th edition, if you want to check it out for yourself. Continuing on, privity of estate. An estate is a trust. Privity of estate means a mutual or successive relationship to the same right in property as between grantor and grantee, or landlord and tenant, also termed privity of title. So, aka warranty deed, a trust, you as grantee, or trustee filed with the county from previous owner as grantor in a successive trust. So expressing the trust by our signature or autograph with an except for value. So trust now exists by the fact that in 1933, when the gold was taken from the backing of the Federal Reserve notes, a contract could no longer be completed. No consideration for value can be given or exchanged to complete a contract. Common law vanished in the public now, not the private. So all contracts become colorable contracts or lies, and a trust rushes in to fill that void. And now every colorable contract is wrapping and hiding a trust as the core. And everything is now trust and the gifting of the res or principal into the trust forming the corpus of the trust. And your signature is the representation of the trust in all your past, present, and future labor or your asset. And your signature is the res, the value, the principal. And every trust, no matter what it is called, technically fits into two kinds or types of trust. Black's Law Dictionary under trust lists the two kinds of trust. That is, number one, an express trust, and number two, an implied trust. And every trust fits into one of these two classifications. Black's Law Dictionary basic definition of trust follows now. Trust, the right enforceable solely in equity. So a trust operates in equity, in a court of equity. That's key. To the beneficial enjoyment of property to which another person holds the legal title. A property interest held by one person, the grantee or trustee, at the request of another, the grantor, settlor, for the benefit of a third party, the beneficiary. So there's your basic definition of trust. Now going on to the two characteristics. Express trust, number one. Black's Law 8 says a trust, express trust means a trust created with settlers' express intent. So in other words, expressing the trust. That's voluntarily. That's voluntarily done. And continuing on, it says it's usually declared in writing. An ordinary trust as opposed to a resulting trust or a constructive trust. And then number two, implied trust. That's an involuntary trust. Also termed constructive trust. A constructive trust is the formula through which the conscience of equity finds expression. When property has been acquired in such circumstances as the holder of the legal title, that's be the 9/10 possessory title, 9/10 of the law is possession, that's the legal title, may not in good conscience retain the beneficial interest, and the beneficial interest is the sole ownership or the remaining 1/10, which is the actual title. Equity converts him into a trustee, and it is sometimes said that when there are sufficient grounds for imposing a constructive trust, the court constructs a trust, or in other words, it implies a trust because we didn't express the trust first. So the expression is, of course, absurd. The word constructive is derived from the verb construe, not from the verb construct. The court construes the circumstances in the sense that it explains or interprets them, and it does not construct them. That's 5 Austin Wakeman Scott, The Laws of Trust, out of Black's Law 8th edition. So the court construes the circumstances in the sense it explains or interprets them, and it does not construct them. Construement. Construes the terms. It interprets them. Why? Because we didn't express the trust first, and we dropped the ball. And when we drop the ball, they're waiting for us to do something, express that trust. We don't do it, so they must pick up that ball and do something with it. Naturally, they're going to construe it on a bias bent on their part, and we're going to fall under liability in our public policy with requirement to make payments with Federal Reserve notes. And if you had expressed the trust yourself, you could have set up the law of the trust, which was the intent of the grantor, and you could have set the trust, expressing it, to be payment with private credit, private instruments. Instead, you got construed under debtor-creditor law instead of a trust law under equity. And that's where the substantive rights of the real man rest and lie, still today. So the cesticate trusts are an implied or construed trust or a constructive trust. See again the Black's Law definitions above. As an example of a cesticate trust is the Social Security number trust account, aka straw man. A cesticate trust is a beneficiary trust of the foreign situs trust birth certificate by the courts construing the trust because you do not express the trust after 18. It's kind of like a spillover trust. Foreign situs trust spilled over into the Social Security trust at 18 and it took effect and you didn't come back and accept it. So the cesticate trust or constructed trust is the remedy through which the court of equity finds justice for the one who has lost his property to one who does not legally have the right to the property. So you're being construed as the one who's holding the property illegally because you didn't make the payments. And he is holding the property illegally when the property has been acquired in such circumstances that the holder of the legal title or the possessory title may not in good conscience retain the beneficial interest or the beneficial title, and then equity converts him into a trustee. And isn't it said that all prisoners in prison are trustees? Isn't that a trust term? So you're construed to be an illegal holder of the property because you didn't express the trust. At age 18, you were supposed to assume the role of trustee through your expression of the trust, and you didn't because you didn't know you had to. You dropped the ball, waiving all your rights to expressing the trust as to law form, parties, duties, etc., allowing them to pick up the ball and construe the trust with a bias bent for them because it was not clear on what your intent was. The courts then construe you as a trustee and breach of trustee duty to pay them as construed beneficiary in Federal Reserve notes. And if you would have expressed a trust with your intent under 1776 law form, which is pre-United States and pre-statutes and codes, being able to pay with private credit, NDIs, or negotiable debt instruments, you would be safe making private payments with private credit, but you didn't. You waived your right by dropping the ball, and they had to pick it up and do something with it. And naturally, they would construe it to their benefit as beneficiaries under construement and ignore your presentments of private credit and put you under public policy, statutes, and codes to pay with Federal Reserve notes. You goofed up, not them. They are culpable for what they are doing wrong by blocking your remedy, but you had the first move and didn't. Now, you can always go back and correct the problem. You come back in even in re-expression of the trust, even in a irrevocable trust, because the grantor has all the power. So if you make payments with your private credit, you can always correct that problem. For example, under the restatement of the law on trust, second, at section 332, which is entitled Power of Revocation or Modification Omitted by Mistake, the settlor can reform or modify the trust to reflect his original intent, even when the courts construe the trust to be irrevocable because you didn't express it being revocable or modifiable. Now, see what power you have as a settlor and you didn't even know? So let's talk about some basic trusts. Since trust law is new to most people, the place to start would be in a line of study to understand the law of trust is to understand the legal mechanisms of, say, the federal income tax systems or the traffic code of the municipal courts or the claims on property taxes, just to identify a few of the trust agreements we've been induced into voluntarily signing. So in general, I can recommend the book, The Law of Trusts and Trustees, by Bogert and Scott on Trust. And I mentioned the restatement of the seconds of the Law on Trust is a very good one. And Wills and Trusts in a Nutshell, that's another one. It's available at bookstores or law bookstores. So in those states for which there exists a trust code, there would also be invaluable information regarding trust law. So check that up on the internet. So some key foundational points regarding trust law. He who claims trust must prove trust. Quote, the burden of proof is on the party who asserts the existence of a trust. Well, that's Bogert, section 50 at 102. And that burden of proof is a prima facie case. And that proof of the trust is really by expressing the trust. So regarding these scams, if you want to call them scams, or blocking the remedy, whatever, since they are typically the fiduciary or the trustee, they're synonymous, and don't even know that we volunteered for the role or position, the threshold burden of proof will be on the party claiming to be, say, the beneficiary. So the beneficiary seeking to obtain a relief for, say, a breach of trust must plead and prove the facts which show the existence of a fiduciary duty or a trustee duty and the failure of the trustee to perform it. And that consequently, the court should grant the requested remedy. And that's Bogart 871 at 156. So where the beneficiary fails to prove the damages, there is no recovery. So what must the party claiming trust prove initially? And there are basically 4 elements to a trust. Number 1 is parties, and that would be grantor, trustee, beneficiary. And number 2 would be a specific res property. And number 3 would be intent. And number 4 would be purpose. And intent and purpose, 3 and 4, is from the grantor. So the trustee, he holds the trust property and is subject to equitable duties and to deal with the benefit for another, and the beneficiary, to whom the trustee owes equitable duties to deal with the trust property for his benefit, and trust property, or the res, which is held by the trustee for the beneficiary. So moreover, a fiduciary relationship necessarily arises when the government assumes such elaborate control or force a property belonging to the Indian, say. All of the necessary elements of a common law trust are present: a trustee, a beneficiary, a trust corpus, etc. And then a trust must have both a beneficiary and a trust property, the res, and if there is no beneficiary or no trust res, then there is no trust. But if there is an absence of a fiduciary or trustee, a court of competent jurisdiction may supply a fiduciary, and equity will not allow a trust to fail for a lack of trustee. So acceptance of the benefits is presumed under Bogart 169, notice to and acceptance by the beneficiary, and at 191, acceptance is presumed. And this is just to say that there's nothing that an alleged beneficiary of these scams need to do to confirm formally acceptance of the role of beneficiary. The beneficiary may disclaim under Bogart's 170-72, the disclaimer in its effect, and 170 at 205, proof of acceptance or disclaimer, where conduct by the beneficiary which is inconsistent with a trust for his benefit may amount to an implied disclaimer. A disclaimer amounts to a refusal to accept a gift of the equitable property right. That's Bogart 170 at 207. In the absence of a statute governing the matter, the problem is often whether the beneficiary, by his words or other conduct, and remember silence is conduct, accepted the equitable interest or has indicated that he rejected such benefits. Since acceptance is normal, a claim of renunciation must be supported by clear evidence. That's Bogart 170 at 205, proof of acceptance or disclaimer. So disclaimer operates back to and as of the date of the start of the agreement. That's Bogart 172 at 227-28, and the phrase nunc pro tunc may appear in this area of discussion, and it means now and for then. Conduct by the beneficiary which is inconsistent with trust for his benefits may amount to an implied disclaimer, and statutes which require surrender of such trust will be in writing do not apply, since a surrender is based on giving up of an existing equitable interest, whereas a disclaimer amounts to a refusal to accept a gift of equitable property right. Bogart 170 at 207. And abuse by an alleged beneficiary, the alleged fiduciary, is relevant to the questions of whether a trust was ever created and of disclaimer. And where it is usual the creation of a trust is by way of gift, the relationship between the settlor and the beneficiary may influence a court in deciding whether a trust intent existed. If the beneficiaries are on bad terms, as where the alleged beneficiary has been mistreating the supposed settlor, the creation of a trust is rendered unlikely. Bogart's 50 at 108. A coerced trust is not evidence of such an agreement. That's Bogart 42 at 434 and 44 at 452. In other words, no one may be compelled to be a fiduciary or trustee. The only way to be a trustee is voluntarily. So this term is included for one main reason. There is a moral level of response of the repulsion that those in government feel the need and the authority to run these scams against us. And these scams feel like fraud. So if the choice of law were the law of the land, then it would be fraud. But the choice of law is not the law of the land, and therefore we need to move through that feeling as quick as possible under the choice of law by which these scams are being evaluated all the trusts that are part of the scams are 100% voluntary. And this does not mean that one should not ever assert these defenses. It just means that those who feel compelled to assert claims or defenses for fraud or duress or coercion are strongly encouraged also to assert claims and defenses that may actually be heard. And under the common law standards, the agreement would be to evaluate per the subjective standard. Per that standard, the relevant question would be along these lines. Did you understand that you were creating a trust when you signed that document? However, under the standard for this state, which standard is the objective standard, about the only relevant question is this your signature? In other words, in an agreement evaluated per the choice of law of this state, one is presumed to know the nature and consequences of what he signs. And while this presumption is not necessarily irrebuttable, we have a choice of focusing solely on the standard, which is signatures, really, or of also digging deeper into the substance of the matter so as to deal with the legal reality of the matter. So in this day and age of the statutes of frauds, the trust agreement must be in writing and signed by the parties to be charged. For our purposes here, that party would be a fiduciary or trustee. And as an example of this idea, we find that this, under Texas Property Code, which is part of this addresses the trust here, under Section 112.004, Statutes of Frauds, a trust in either real or personal property is enforceable only if there is a written evidence of a trust terms bearing the signature of the settlor or the settler's authorized agent. The trust consisting of personal property, however, is enforceable if created by, number one, and these are two of the four methods of formation. Number one, transfer of the trust property to the trustee, who is neither settlor nor beneficiary, if the transferor expresses simultaneously with the prior to the transfer the intention to create a trust. Or number two, a declaration in writing by the owner of property that the owner holds the property as trustee for another person, for the owner, and another person as the beneficiary. So heads up next. Bingo. If the beneficiary makes a prima facie case, the burden of contradicting it or showing a defense will then shift to the trustee. That's Bogart 871 at 156 and 57. See also the Scots on Trust, section 172 at 452 through 53. And Bogart 861 at 2 and 3. So the burden of proof issue is one of the most significant distinctions and characteristics about trust law. I'll read that again. The burden of proof issue is one of the most significant distinctions and characteristics about trust law. There is no obvious transition from the threshold burden phase to the substantive burden phase. And here's where we want to compare, say, the case U.S. versus SNEP, where the U.S., which was really the CIA, came against SNEP, who was a 15-year employee of the CIA. And he signed in there, signing a contract, that he wouldn't write any information and publish it without prior written consent from the CIA. He worked there 15 years, and then he quit. And before he quit, he signed another contract to the same effect. So they had two written contracts, two written signatures on a contract for not publication of any kind of data which would not be prior okayed by the CIA. So with that, you would think that the U.S. or CIA would come against SNEP under contract tort law. No. They sued him under trust law. I wonder why. The burden of proof issue is one of the most significant distinctions and characteristics about trust law. There is no obvious transition from the threshold burden phase to the substantive burden phase. However, where the party claiming trust is the beneficiary, what happens is what is referred to as a shift in the burden of proof. Thus, where it is beneficiary who is asserting trust, then the beneficiary is expected to be the party who files the suit or the claim, because the threshold burden of proof is on the beneficiary. Then, once the beneficiary satisfies the threshold burden, the burden of proof shifts to the alleged trustee. What does the trustee then have the burden to prove? The fiduciary then has the burden to prove compliance or non-breach. And he has no evidence that he can prove, unless he made the payment. So the thing, they go on the presumption, quote, why would a beneficiary make a claim if he got paid? And the trustee would have that proof, and why would they make that claim unless the trustee has not paid? So the point to make here about the evidence, and that's the key, the beneficiary has paid. So the evidence and the burden of proof is that once the threshold of burden is satisfied, the law of trust presumes that the fiduciary or the trustee is wrong, or is guilty, or has breached the agreement, as it were, and the fiduciary must prove, which he can't unless he's made a payment, that what he did was consistent with the applicable trust agreement. And that's the grantor's intent. And with the applicable trust laws. So thus in civil context, now that's commercial context, the trustee is quite literally presumed to be guilty or presumed to have breached. And he must prove that he was within the terms of the trust and within the applicable trust laws, that is, not guilty. And he can't do that without proof of performance, which he didn't do. So the terms of the trust determined by the grantor, who sets up the law of the trust, example, make payments with private credit through the strawman trust account. That would be the terms of the trust. So continue on to review this in a context which we'll find ourselves regarding this government-sponsored scams. The threshold burden is on the beneficiary. That party must prove up, in other words, a prima facie case. Number one, beneficiary. Number two, trustee. Number three, trust res, and intent and purpose of the grantor. Then after that, and only after that, threshold burden is satisfied, the burden of proof shifts to the alleged fiduciary trustee, who must then show compliance as in non-breach. So how do you prove up a prima facie case? That's simple. Do like they do on any mortgage foreclosure. Come in with copies and make an allegation. It's all prima facie. It's presumed that you're guilty. So look at it another way. While it's indispensable that the trustee carries the burden to show compliance with the trust agreement, it's just as indispensable that such burden doesn't even exist until after the beneficiary carries the threshold burden to show, number one, that the claimant is the beneficiary, number two, managed by an alleged fiduciary, a trustee, and three, of a trust with a trust res. In other words, express the trust. So if there is lack of any presumption of death or grant of power to pay a substitute, the trustee may pay the funds to an alleged successor of the absentee at his peril, or hold them indefinitely, unless he can secure protection by the court. That's Bogart 814 at 314. So this is the unknown beneficiary problem, which can be your defense. And where the alleged beneficiary is unknown, then the alleged fiduciary trustee has no duty to or obligation to such a party to pay. Now when you walk into court and they construe you to be the trustee in breach of trustee duty because you didn't pay, what would your defense be? Would it be the unknown beneficiary problem? Since the trust wasn't expressed on either party's part, then how would you know who the beneficiary was? And as a construed trustee, you could claim the unknown beneficiary problem and hold the payment indefinitely until the other party tells you, identifies who the real beneficiary is. Or you could come back in and re-express the trust and modify it to your liking and express yourself as the beneficiary. So the typical identification here would include the name and address, so you could identify who the party was that needed to be paid. That's Bogart 161 at 133 and 34. So the breach of fiduciary duty can be a criminal act. In other words, trustees go to jail as trustees in prison. And that's misapplication of fiduciary property or property of financial institution. And you can also see embezzlement and willful misappropriation. And sometimes the term fraud includes embezzlement, and defraud derives from common law, and embezzlement is a statutory concept, generally known to common law also. And larceny, on the other hand, is a common law concept. And thus, in general, where defraud takes its meaning from the common law, it would include larceny, but not embezzlement. But in the statutes, defraud can also include embezzlement. And in this case, for example, under 18 U.S.C. 371, where defraud includes embezzlement. So to conclude this little article here, Primer on Trust, let's look at one example to facilitate understanding of this example. Let's add one more foundational concept from trust law, as already identified in the burden of proof discussion. So the fiduciary or trustee must act within the terms of the trust agreement. And how would they know what the trust agreement was unless you expressed it in some way? And keep in mind, expression of the trust can be oral or it can be in writing, and that your silence can also be construed as an act or your conduct and your agreement to the trust. And he must be able to prove that he has acted in compliance with the terms of that trust agreement. However, the fiduciary may act in contradiction to the agreement where all beneficiaries agree to that deviation. And that's Scott on Abridgments, Section 216. So by way of an introduction of an example, let's say that there are several beneficiaries, and let's say that the fiduciary wants to make a donation to a new charity, which entity was not previously named beneficiary of that trust, and let's say that all but one of the named beneficiaries supported the idea of making that donation out of the trust property. Can the fiduciary or trustee make that donation? No. And why not? Because it'd be a distribution of trust property to a non-beneficiary without the unanimous consent of the named beneficiaries. What is called sometimes where the fiduciary deliberately makes an unauthorized distribution from the trust is embezzlement. So I gave an example there. If you would come into court, well, there was a case that Chief Justice Fuller stated, where the justice of a court of equity to prevent any threat and breach of trust and the misapplication or diversion of funds and the corporation by illegal payments out of its capital or profits has been frequently sustained. And he goes on with some case cites, and this bill proceeds on the ground that the defendants would be guilty of such breach of trust or duty involuntarily making return for the imposition of and paying an unconstitutional tax, and also on allegations of threatened multiplicity of suits and irreparable injury. In that case was Polk, who was a beneficiary, versus Farmers Trust and Loan, 157 U.S. 429, 1895 case. So to review, reflect on the fact that at the time of the original 1894 income tax program, the United States was not named beneficiary to any farmers' agreements, and thus were at least one beneficiary, who was Polk, a shareholder, withheld consent to any distribution to any unknown beneficiary, in other words, the United States. Then for the fiduciary, the director of farmers, to make such distribution would be for them to breach the duty of loyalty and to engage in criminal conduct. And as the court tells us in this very first paragraph, the Polk case was never about direct or indirect taxes. It's just one more run-of-the-mill trust case with several hundred pages of diplomatic judicial discussion that exists to salve the ego of the beneficiary, of those asserting unfocused, manifestly distracting arguments. So I hope those people that are on the call out there, I know some of them are out there, have been on this call before, and they understand some of the stuff that I've been talking about. So I hope I didn't lose a lot of the listeners here But I'd like to focus in on where the key is, and that's the rule of the signatures in expressing the trust. So we have three main parties to the trust, and that's grantor, trustee, and beneficiary. And there's really only 5 types of signatures. You have a clean signature or an unqualified signature, just the way you would normally sign your name without any restriction on it. And it was no qualifiers with it. Now a qualifier would be restricting the signature, and that would be signing in a particular way, and that particular way would be by grantor and then the signature. That's restricting the signature. That's making a qualified signature. Or we could sign by trustee and the signature. Or we could sign by beneficiary and the signature. So it's like one party can wear many hats. You are at one time or another going to be one or all 3 of these parties, but not all 3 simultaneously. You could be grantor and beneficiary in one kind of a given moment under a circumstance, and be grantor and trustee under another. And I would operate trust more or less under grantor, trustee, being the same parties, but wearing different hats at different times. And that would be operating out in public there or at law. And if I ever got pulled into a court case, then I would put on a different hat. I would be grantor and beneficiary. So you have unrestricted real man signature that's unqualified, that every time it is seen in the public is going to be construed as the straw man. And you just gave it the whole ball of wax away. And all these courts and all these agencies are always trying to do one thing. No matter what the case is, the charge is, the bill that comes in the mail under UCC 3-115 as an incomplete instrument, looking for a signature in addition of words and numbers to make it into a check, a negotiable instrument that can be accessed through your exemption. All these agencies and courts, that's all they're trying to do. And they're looking for you to trick you into voluntarily giving your signature so that they can gain access to the Social Security account. And what you sign or how you sign is going to be the determining factor of whether or not they gain total access to it or whether you do. The choice is up to you. If you give an unrestricted signature, a clean signature, you're giving the ball of wax away. But if you sign by grantor, trustee, beneficiary with a qualifier and then the signature, you're restricting the signature and you're limiting access to anybody else except yourself. And there's one more to add to make up the 5. Review. Number 1, the real man's signature. Number 2, grantor, by grantor and a signature. Number 3, trustee, by trustee and a signature. Number 4, beneficiary, by beneficiary and a signature. Number 5, the 5th one, is authorized representative. And that authorized representative term is a portal term, I call it, because that portals into UCC debtor-creditor relationship under UCC 3-402, where the authorized representative is signing for the contract. But it also can apply to trusts with a Form 56 appointment by the grantor or by the trustee to another party who has the authority been given to them to authorize them to act as the authorized representative as possibly a co-trustee. So now let's review the duties of these parties. The grantor, he's the funder of the whole thing. He's the private banker. The trustee, he's the receiver of the documents, and he's also the payer of the bills. He's the one who ledgers the accounts and puts in the liability side what is going to be paid out. And he's the one who signs the checks and pays the bills of the trust. And then you have the beneficiary. They're going to pick up the disbursements of the trust, and they're the only one who can make a claim for a deficiency. Then you have the authorized representative, who could be trustee's assistant as a receiver of the documents, and he could also be the trustee's assistant of the payer of the bills by the private contract on the Form 56. by the trustee or by the grantor. So you have the trust name, which is the all-caps straw man name with the number on it, which is the trust account. So as you function, you're going to have to give a special key restriction to correspond with the duty that you're performing, and that is going to be looked at and compared with what you're trying to accomplish in comparison to how you're signing. Just like a key fits in the door, unless the slots are cut just right, the key will not open the door. And the key to opening the door is the rule of signatures in expressing the trust. Just like on the movie National Treasures, when he put that funny-looking key in the slot there, the whole world opened up to him. He got access to the treasure. The key to accessing the treasure is the rule of signatures and the rule of forms. So the signature equals the expression of a relationship, which equals the intent and purpose. And a relationship can be a trust, a fiduciary relationship, an agency relationship, a debtor-creditor relationship, and there are others. Bailment, administrator, executor. But not all these relationships have all the same elements as a trust. A trust has 4 elements to make it a trust that the law will recognize as a trust. One of these other agency, fiduciary, debtor creditors, or others, these relationships, lack one or more of these elements. In order for it to be a trust must have 4 elements that the law recognizes as a trust. And number 1 is intent. And number 2 is purpose. And that's the intent and purpose of the grantor or the settlor. And number 3 is parties. You must have a grantor, a trustee, and a beneficiary. And number 4, you have to have specific trust res. So the definition of a trust was a relationship that was formed with relation to specific trust property on behalf of the benefit of a beneficiary. So those 4 elements is intent, purpose, parties, and specific trust res. And you have a trust. And then there was the formation of a trust. Can be by words, number 1, and that could be written or oral. Or it can be number 2, conduct, which can be by silence as an act or conduct. So it's by words or conduct. You're forming a trust. Then there are 4 methods of formation of a trust, which you must have at least one of these 4 methods to form the trust, including with the elements. Number 1, first method of formation is declaration. And remember, that's by words or conduct. Number 2 is transfer. Number 3 is appointment. And number 4 is contract. So number 1 again is declaration by words or conduct. And number two, transfer. Transfer is a portal term again. Transfer is also under UCC Article 3, Part 200, where it talks about negotiation. And a transfer or negotiation is by 4 methods. A, endorsement. B, delivery in bearer form. And C, assignment on a UCC 3. And D, by operation of law. That's negotiation under UCC, which is transfer. But transfer is also a trust term. A transfer, using one of these methods, forms a trust. So, number 1, declaration. Number 2, transfer. Number 3, appointment. And number 4, contract. You can have a contract that would form a trust in the future. So there has to be a specific transfer of trust property in the now, in the present sense, for a trust to form, or else it's in the later date, and a trust is not formed. Now keep this in mind. This is very important. This is key here. No parties in a trust need to know or understand they are forming a trust. Let me repeat that again. No parties in a trust need to know or understand they are forming a trust. That means the grantor, the trustee, or the beneficiary do not need to know or understand what they have done. This is how they're getting you. You may ask, well, how did they form a trust then? Well, it does not negate the trust for the fact that they do not know or understand what they did. The fact that they did it, if they have the included 4 elements of a trust, and they did one of the 4 methods of formation of the trust that the law recognizes as being a trust, they formed a trust, unbeknownst to themselves. And since the trust was not expressed because you didn't know or understand, now the courts will construe it, and they will construe you under their own bias bent to whatever they think is what you meant. So, no parties of the trust need to know or understand that they are forming the trust. That's the grantor, the trustee, or the beneficiary. It does not negate the trust. That is Section 23, Restatement of the Law on Trust II. And also out of Gilbert's Law Summaries on Trust, page 19, Section 67. Check it out. The one who is able to prove the expression of the trust elements and has the burden of proof to do so. If not, there is no trust. So when you go to court, and so I've examined some transcripts of some patriots that go in there, and they want to talk about this Sesta-K straw man trust, and it exists, and House Joint Resolution and everything, and the judge says, I don't see a trust here. That was the door wide open for you to bring in an expression of the trust, and if you didn't, there was no trust. Because you failed on the burden to prove by expression of the trust elements that there was a trust, and the burden would have shifted to them to say otherwise, but you never expressed it. And now you allowed them to construe it, and they're going to put you under debtor-creditor law under a UCC-1 filing and a financing statement for your mortgage, and they're going to construe it as a debt. And instead, you had formed a trust from the beginning, and it was in-kind promissory note in with in-kind promissory note back out on a special deposit, a trust deposit, and if you would express that from the beginning, your house would have been paid, and your mortgage, and you got your house, and everything would have been taken care of. But no, you never did that. You were construed under debtor-creditor law to be a debt, and now you owe on an unconscionable secondary contract that you get to pay for 30 years on. Bingo. Now, realize what you've done wrong, study trust law, come back in and expressing the trust, use NTT technology, new trust technology, learn what it's all about, and come back in and correct these problems.
Kristen, can we ask questions?
Yeah, we may open it up to questions now. I was just going to check the time here. 8:08. Yeah. State your name, where you're from.
I'm John. I'm from Phoenix, Arizona, and run around with guys like Jack Smith and Gordon Hall, and firm believer in everything you're talking about. And I stumbled across something because I'm involved in a rather high-profile case. And I know that in order to handle this case, I've got to express the trust. Now, what I'm thinking of, that I don't know how much time you've spent in actual court and dealing with the procedures, but I'd like to get your opinion on the theory of using an amicus curiae brief, taking the actual defendant in error, saying, okay, he's, without going in like Rule 17A and all that, and saying, okay, say I'm the person they're coming after. I do the amicus curiae brief as the party that has the interest. In other words, in order to do that, you can't be a party to the case, but you have it to have an interest in the outcome of the case, i.e. meaning if something happens to the defendant, it's going to radically affect your position either equitably or physically. So if, say I'm the defendant and I say I am the beneficiary for the defendant, I'm authorized also the authorized representative. So, therefore, I have the right to put in an amicus curiae brief, because if something happens to this defendant, you are going to you being the court, are going to misrepresent the trust. You're going to make certain claims that are not correct. Therefore, I am stating what the trust really is, and because of that, this defendant has to be negated from the case, because no matter what you're doing at this point, that defendant being a fiction cannot be involved in this case, therefore it must be removed. There would be an awful lot more to it, obviously, but what's your opinion on that?
Well, I think you're making it too hard, because once we get our minds wrapped around here about expressing the trust using NTT, new trust technology here, that I think it's going to simplify things a whole lot more. A lot of that stuff I would be doing in private in chambers, submitting my evidence, setting up the fact. If I come in with an NOI, a notice of interest, that there's a trust, if I don't follow that within 30 days with a statement of interest to back up with the material facts as to say that I am the grantor or I am the beneficiary, within 30 days that claim is going to time out. And they're going to continue on with it anyway. But where I want to produce those material facts those records, is in chambers. Because if I put it into court, I'm going to open it up for, waiver, because under the federal laws, Rule 501 in general, but comporting to Florida statutes in particular, 90.506 and 90.507 is talking about protected matters. And I don't want to waive the privilege of voluntary disclosure under 90.507 of my confidential commercial information or my private substantive rights of the man, the records that I proving the fact that I am the beneficiary and the grantor. Because under 90.506, that's privilege with respect to trade secrets. And that's what this is. Trade secret information is private. And I need to keep it private. Otherwise, if I'm going to put this in open court, I'm going to waive it. And that's why we're getting hammered in courts, I believe, because we're putting it on the public side, putting it in through the clerk of the courts when we should be putting it in by private letterogatory in judges' chambers and calling for an in-camera hearing. But I would think there would be something, I would do it a little bit different. I would merge the titles. Merge the titles and close the case down. Anytime any one of the parties in a trust, when the two titles are in one party, the trust terminates. And I'm trying to get away from the verbiage that we've been using a lot, and that's collapsing the trust. No, we're not collapsing the trust. I don't see anywhere in trust law where it talks about collapsing a trust. It's terminating a trust, modifying a trust, or revoking a trust. So I want to maybe, under this situation, in this court case, I would want to terminate the trust. And if I can use the moving titles platform in commerce, that platform, and create the titles if they don't exist already, then claim the titles on a UCC1, and then move the title with a UCC3, moving that asset, that trust res property, to the trustee or to the beneficiary, whichever way we want to play this, and move the beneficial interest, say, to the legal title holder, who would be the trustee. Now both titles are in one party and the trust terminates, and that trustee no longer has trust protection. And now they're personally liable for what's going down, which is they'll be in breach of fiduciary duty and also breach of trust if they do not distribute the funds. So if I'm coming into court and the judge says, well, I got your documentation, but I'm not the trustee, I refuse that. So he disclaims that. Well, here's what I would do. Once he says that, I'd say, that's fine, Judge, but now you have just formed, I might not tell him all this in court, but this is what I'm thinking. You just formed a resulting trust, and now you're in equity, and equity must not let this trust fail. You must appoint a successor trustee. Now, once you appoint that successor trustee, you let me know by name and address who that trustee is, because now I am, as grantor, am temporarily holding this trust res property as trustee until you appoint a successor trustee and I have its name, and then I can transfer the property res to this successor trustee so that he can give disbursement to the beneficiary. What can they say to that? Welcome to NTT Trust Technology and Moving Titles and Commerce Platform.
Hello, Christian.
Yeah, Dave, go ahead.
Thank you very much. Simple question. The trustee that you're going to transfer this to, the guy that you name, is that correct? You're going to name a new trustee after you fire this is in a mortgage case. The current trustee, which is the bank's trustee, does something wrong that, or you just don't like him and you fire him and you replace him with your own trustee. Is that correct?
Yeah. But my whole key position would be to merge the titles. When I merge the titles, and I'm going to...
Okay, so then we got to back up a little bit then. In a mortgage case, you're talking about transferring the res. Can you give us an example how you would do that, or the different ways you can do that?
Okay, at closing, the res would actually be the promissory note that you sign.
Okay.
What you did is you...
Now...
Go ahead.
Well, in a mortgage situation, you're not typically going to have your own NDI submitted. That's negotiable debt instrument. But I wanted you to explain the public policy, Ray, the private instruments submitted, and the only way to submit them so that they benefit the issuer.
That would be, you'd have to express the trust, because only that way the trust law, or the law of the case, is going to be determined by the intent and purpose of the grantor. And how could the grantor or anybody else know unless the grantor expressed the trust? So, a trust is an act.
Good.
It's not under public policy.
Okay, thank you. One last question. You mentioned that you need to record a notice of these documents and not the actual documents themselves numerous times. If you mess with it, is it fatal if you recorded the notice with certified copies of the documents as well?
Copies? No, I don't. I wouldn't want to put copies in. I would just want to make reference that the payment instrument exists in the private.
Right. The notice is sufficient, but in cases where...
I don't think that would be to make it defective, though, with copies.
You still have possession of the original, so that's the key issue.
Yeah, by the way, the rule of forms is you keep the originals, except of everything except negotiable debt instruments that you want to make payments with. You don't keep those. But the rule of forms is that you keep originals that you sign, which is the reverse from what, because they keep the originals. No, I'm going to make copies and give them the originals. That's the rule of forms.
Well, I appreciate all the work you put into this. This is just tremendous information. Thank you.
Well, I think we went over before that if you picture in your mind or on a piece of paper that if you drew a circle and within that circle you drew an upside-down dotted T, an upside-down T in dashes. So you draw a line down through the center of the circle about almost to the end, and then you draw a cross line under that and you form an inverted T. All right, this whole circle is Mr. Bank. And then below that you would draw another circle. And this second circle is you as grantor. So what you're doing is you went to the bank and you applied for a mortgage, and your signature created an application of credit and gave them power of attorney. So with that power of attorney, then the bank appoints a title company to be your trustee. So there's a third-party title company off here to the right, say, and the bank is the beneficiary. Because I went over on a case there was on Nevada. They made reference to Nevada revised codes, and it was a federal bankruptcy case that the judge in the case said that the payee on a note is the beneficiary, and he also said the maker of the note is the trustee. So the trustee is the maker of the note, and the payee is the beneficiary. So on your note that you signed, you were the grantor, and the payee on the bank would be the beneficiary. So Mr. Bank is beneficiary here. So on this ledger that we've just created here, the right side is the assets. That's the trust account side. And on the left side, that's the debtor's asset side. That's the liability side, the minus side. Now, according to GAAP, at the end of the day, both sides of the ledger must balance. They must come to zero. So you signed your note and you gave it from the escrow company here. Now the escrow company has a contract with the bank stating that as soon as you sign the note, they're supposed to jam up that note to the bank. And if they don't, they're dinged a penalty for every day that they don't. So they're in a hurry to get the note to the bank. And when the note gets to the bank, they're going to put it on the asset or the trust side of the account that we created here. Now on the left side, to balance this account, they should have filed a UCC-1 financing statement with a security agreement on it. And those two things have, formed this account, balanced this account out. But before the closing, the bank had, off of your application and your signature, created the funds necessary and advanced them before the closing to the trust company, the title company. Where did they get that from? They got that from your signature on the application. You haven't signed the note yet. So your signature created that first advance, and you didn't even know it. And also, your promissory note was sent to the bank, and you were forming a trust, and you made a special deposit, a trust deposit, and you should have got the same note that you deposited in, held in trust, back out, but you never asked for it back out. So you abandoned it, and now the bank is using it whatever they see fit because they're construing it in this trust and making all these investments for you, and they're securitizing your note, and you're still not making any claims to it, and therefore they're getting to use it, and all those funds are yours. Now what we would do is
So tell us how...
Yeah, what we would do
Tell
is...
us the easiest way to make a claim.
Well, what we would do is we would get them on a validation of debt, and when they don't validate the debt, we would get them on a dishonor. We would use that dishonor for a revocation of the power of attorneys that we signed, the signatures on the power of attorneys, and we would revoke the signatures, and we would come in re-expressing the trust with a reappointment of trustee. Now remember, the title company is the trustee. So we're going to reappoint not the title company being trustee, we're going to reappoint the bank being trustee. Since the bank is the beneficiary, and we appoint them trustee, now what happens? The trust terminates.
It can be both.
The trust terminates. And what happens when the trust terminates? They must disperse funds to the beneficiary. And who is the beneficiary? The bank. So at that moment, once you express the trust, which you should have done at closing, the bank is both trustee and beneficiary, who must now terminate the trust and then as trustee pass it on to the beneficiary, which is the bank, closing and settling the case, the count. At that point,
Therefore,
the mortgage is done. And now
they release the lien.
You collect funds that were generated off the investments of the note. because those are yours.
Yeah, what about that?
So you as grantor
have an audit?
express trust as trustee orders to disperse or distribute the funds to the beneficiary so that as trustee they construe through the courts the assets as a debt under debtor-creditor law, and they invest the assets held in trust by securitizing the assets. So they commingled the funds, in other words, in a breach of trust, in other words. And they've been waiting for the trustees to orders to distribute the funds that have been abandoned. And those orders are supposed to come from the grantor, but you see, you never knew or understood that you were a party to this trust, and according to the restatement of seconds under 23, you didn't have to. But then that puts you under the debtor-creditor instead of under trust law. So under debtor-creditor law, you now have a debt to pay for the next 30 years. Welcome to NTT technology.
So you wouldn't bother going back and correcting that as the grantor?
Yeah, I would have to re-express the trust again. Correct what should have been done at closing or after closing.
Do you think it's possible to do that right after closing and then going ahead and letting you get the house?
I think it's possible to get the house after you lost it, or at least
that'd be great.
I would definitely get the proceeds.
Well,
I really wouldn't want to put the new owners out because they were a bona fide purchaser, and because I didn't give them notice.
Abandoned. Right.
Yeah, it's been abandoned. But if I didn't accept for value under 3-303, where it states in there that you're establishing holder in due course status, and now whoever's holder in due course is really the one with the big kahunas. And that's why it was important for that case, that Oklahoma Supreme Court decision that stated there that they were, the first thing that case established was that they must find out who the holder in due course was. Because the holder in due course had the right to cut off. Let me see if I can find that here. 1966, Oklahoma Supreme Court explained the importance of applying necessary elements, in other words, UCC, to confirm that an instrument had been taken for value. Why? Except for value establishes the holder in due course standing. That's why. So they went through all this, and they said that was the first thing that they had to establish.
What item are you going to accept for value 5 years after the fact that you lost your house? That's just my wild, crazy guess.
Can you hear me? Can you hear me?
I'm interested in knowing how many other people are on the call.
Please, you are now unmuted.
Okay, I'm here. I got knocked off. Can you hear me?
Yes.
Okay, I missed your question.
Question was, 5 years after the fact on a foreclosure, what instrument are you going to accept for value so you can take this process?
Do you have any of the original documentation?
You mean like the court judgment or the court, the pleadings?
Yeah, anything that's the original charging instrument. I do an accept.
Okay, it has to be
and then that would
be a charging instrument.
Yeah, that would establish the holder in due course status, and that gives you cutoff rights.
I think in non-judicial states that might be some states have an application for foreclosure, and other states they just publish a notice in the public somewhere before they foreclose.
Could you use a certified copy from the clerk's office?
Yeah, certified copy would work, yeah. I mean, there should be some court records that's still open that you should be able to get certified copies from.
Well, there you have it, folks. All you people who lost your house, now you can get it back. All you have to do is sign up for Kristen's new program. You got to get on the list. You still going to have your classes?
Yeah, I'll be announcing them shortly. It'll be the workshops. Yeah.
Well, hurry up, please.
Doing titles and commerce shop, applying the NTT new trust technology. But that's why that Supreme Court case was so important, because the element of taking for value was very material to their case, because that set up the holder in due course status. Now, once that status has been set up, now the other party has no defense to the claim to make the payment. In other words, they can't say that your negotiable instrument was no good, or we don't take these kind of funds, blah, blah, blah. They can't claim those defenses.
What was that case citing?
Yeah, that's...
Car, the one in Oklahoma City?
Yeah, it's Oklahoma, 1966. It's People's Bank of Aurora versus HAR, H-A-A-R, 421 P. 2nd, 817, 1966.
Can you repeat that?
Yes, People's Bank of Aurora, A-U-R-O-R-A, versus HAR, H-A-A-R, 421 P. 2nd, 817. 1960.
Thank you.
This case was about negotiable instruments under Article 3, or UCC, and they were talking about the meaning of value, where the general definition of Article 1 value said that it does not apply to Article 3 negotiable instruments. And a negotiable instrument can be a promise, be a note, signed by the maker. It can be an order or a draft signed by the drawer. And a person who is entitled to enforce the instrument, that be the holder in due course, is the one who decides if it's a promise or an order, unless its terms are required to be one or the other. That's personal choice. Yeah, we went over holder in due course status and what it does. There's a lot of stuff that the importance of holder in due course as it pertains to what is really happening, what it's capable of doing. Most people don't understand. They think it just you put a red stamp across something and that's it. No, it goes much deeper than that.
Well, are you saying that you would somehow become holder in due course of your original note that you signed?
Yes, yes.
And what's the best way to do that?
Well, you have to create a title. So, say if I was going to promissory note, that would be a title I'm going to create. So it already has specific numbers and parties on there, and I would just file a UCC1 and put it in collateral block 4 that a promissory note exists of such and such number. And that's sufficient notice right there on a UCC1. So now I've claimed it. It's mine.
So when you say box 4, you mean on the UCC1 financing statement?
Yeah, the collateral block, yeah.
Okay.
So then I would
do you need to
get a certified copy of that, and now you've got a record. But you need 2 records. You need 2 witnesses. So then I would also do the same thing into the county, put in a notice there of the same thing, pull that out certified. Now I got 2 signatures under seal, or 2 notices, or 2 witnesses. Now you just mirrored that simple private thing into the public. You mirrored it into the public so it can be seen. Now they have to act on it. Now you've claimed it.
So to be real clear, the note that you signed at closing, you take the number off of that, and you put on collateral box number 4 in the UCC1 that you own that.
Yeah.
That you're the holder in due course of that note.
Yep.
And you do the same thing in another place.
Yep.
And then that's your private commercial information that you're going to show in chambers through letter rogatory or another way.
Yeah, those are. I'm going to have 2 records that I claimed it. I'm going to have 2 records that I moved it. So we got to move it yet. Now
is that with the UCC3? The UCC3.
UCC3, right? Moves it. That's the tool that we.
You're going to move it. You're going to move it to who? The trustee?
Yeah, the trustee. I'm going to make the trustee the holder. I'm going to assign it to the new trustee, which is going to be the bank.
Now the new trustee.
Yeah, the bank.
Okay. In a lot of places, the current trustee is some attorney that the bank gave it to.
Well, it could be.
Or assigned.
Yeah, but
You're going to terminate him?
Terminate him, yeah. Fire him, get rid of him, and then do a reappointment of the bank being trustee on a re-expression of the trust. And now, once I form res property and transfer it to the new trustee, the trust is formed. So now he's been assigned, the bank is now trustee, and when I give them the trust res property, the promissory note on a UCC3, it's been transferred, and transfer is one method of formation of a trust. Now the holder has liability. But this is all debtor.
So it's just a simple matter. Once you do your year 1 and year 3, you notify the parties.
Yes, because now
what you did.
The payee on the note is the beneficiary. That's the bank. And then once I transfer them the note as trustee, now they've got both titles. They've got the legal title as trustee, and they've got the beneficial title as beneficiary. Now the trust terminates. Now they have no.
So as an operation.
Now they have no protection. There's no trust protection. They can be hit for fiduciary and breach of trust if they don't zero the account, because now they're supposed to transfer or disperse the property, the promissory note, to the beneficiary, which is the other side of the ledger in the bank, zeroing the account out.
Have you done this yet? That just sounds too easy.
We got to get down to the paperwork.
This occurs as an operation of law. Are you saying that?
Well, we could run an administrative process on that, yes. Do it by notary presentment, yeah. That's the only way I would do it.
Right. So when they default by not doing it.
Yeah, res judicata estoppel.
You are a genius.
I don't know.
Well, I only know a couple.
Where were you last week? We missed you.
Hey, I was in Phoenix learning how to do the widely held fixed investment trust.
Okay.
Yeah, I wished I could have made it, but it was 4 o'clock out there when you have your program, and I couldn't get out. To run up to my room and call you on the phone, and all I could have done was record it, and I didn't even get to do that. But I did get to hear you on the talk show like a couple of days later.
Right.
And that was like a prelude to this program, was it not?
Oh, yeah, it was. Yeah, by the way, I'll make a mention of that. On Wednesdays at 8 o'clock Eastern Time, I'm on TalkShoe, and that number for TalkShoe is 724-444-7444, and the PIN number access is 41875 pound. Every Wednesday night at 8 o'clock, and also on Money Banking and Trust on every Saturday at 9 p.m. Eastern Time. Been doing that show for quite a while now. So
now, my question would be, let's say you do this and you notify the parties of what's just happened and notify them of the record, the notice in the record, and they just, they don't even care. They just go ahead and do their thing like you didn't even do anything.
I would
you said that's a pretty...
I would expect that.
Yeah. So how are you going to stop them from throwing you out of your house?
Well, you're going to have to come in with maybe an independent action, or you're going to have to come in with a counterclaim or countersuit, and you're going to have to maybe put an injunction in based on trust.
But are you still going to go into the chambers privately and make the judge aware of the situation?
Yes, I would, yeah. If I'm got a court case.
Right. Now, typically, would you do that by mail, or would you have to actually ask the court coordinator to make a call for a hearing?
Notary presentment, all the private documentation, but then I'd be working with the judge's JA, assistance for setting up the hearings. And
so you just do a super protest on the court clerk, basically, or at least that judge's clerk.
Yeah. Do an order of presentment through the private side of the court.
Man, that's just too easy. That's marvelous.
Yeah, I don't expect them to roll over.
Mom always said it's simple. Who is that? Ockman's razor. That's, you heard of that, right?
Yeah, right.
Simple answer is usually the correct one.
Kristen.
Yeah. Go ahead.
You got any other callers there?
You broke up. What was it again?
I said, do we have any other callers out there wishing to ask questions?
Oh, sure. Yeah. Dave, you're hogging up the whole show. Anybody else have any questions? Press *1 and state your name and where you're from. If anybody else would like to ask a question.
Yes, I have a question.
Hello, Kristen.
Hello.
Yeah, hello. Just one at a time here. I heard a fella jump on there. What was your name, sir?
Yeah,
Oh,
my name is...
Oh, two of us. Go ahead.
My name is Guido. And on mortgages, many times we're paying a mortgage to a mortgage company that purchased the mortgage from the original mortgage company. Now, when you see these notes, the note never seems to change. It's still in the name of the original mortgage company, although this second mortgage company seems to be holding it, and that's who we're paying.
Right.
So when we make that mortgage company the trustee, do we go after or go to that original mortgage company whose name is on the note, not the one we're paying?
All right, the original mortgage company is where I would go first.
Okay.
The other one's just a pooling and servicer agent for the securitization.
What can you tell us about
Daryl.
workshops?
I have a question.
State your name, where you're from.
Daryl Smith. Just to tack on to the question that was just asked, what if the first mortgage company has been bought out by another company?
Who's the successor?
So do you go after them?
Yeah, the successor. If they don't exist anymore,
Successor.
the successor does, yeah. They've accepted the liability when they did the purchase of the buyout.
Okay. Now I called my successor just the other day and asked who owned the note, and they replied back that such and such Wells Fargo was the investor, and that they themselves serviced the investor. That's how she answered me.
Yeah, see, all this stuff, they're getting you under the debtor-creditor laws, under the unconscionable contract you sign. I'm going to come back and I'm going to start applying trust. That's been our problem all along. We've always known these little trust terms here and there, like, we know that prisoners are called trustees, and different things like that. But here we shift our focus from trust, and we go right back into working about UCC and debtor-creditor and all this stuff. We get pulled back into that trap. No, I think we need to start focusing on trust and start living, eating, and talking and sleeping trust. Because we're operating in a trust all the time. We are a trust. That straw man is a trust. You're the operator of it. We need to learn how to put the hats on of a trust and function as a trust in commerce. So we need to start in trust all the time. Don't get pulled back under this debtor-creditor stuff and UCC stuff anymore. Although...
Yeah, Ed from Michigan?
Yeah, go ahead, yeah.
Yeah, I want to thank you very much. I have been listening to Chris, and Kristen, and I was involved in the foreclosure. I was involved in getting evicted. Now, I don't know how one could be abandoned from the house with a court order for you to leave. That's coercive, and that's by force. But the main thing is, what I had noticed is that if the bank or the mortgager or whoever that may be in question, the lender, cannot prove that they are the holder in due course, they cannot prove that they are the real party in interest by way of validation, then they can't do a doggone thing to you. Secondly, regarding about the trust, you do have a natural person who signs the trust, which is a settler. Then you have the trustee, a trustor, which is your name also. Then you have the trustee. Then you have the beneficiaries and the fiduciary, of course. What I'm saying is this. So long the grantor or the settler decides to modify the trust, he doesn't need any acquiescence, or he doesn't need any approval from the beneficiary or the trustee. He can fire them at any time. But before they can even apply the trust to you, to my understanding, is that they must produce the note. You cannot sell the house, foreclose on the house, in absence of the note. One will work with the other. It's coexistence. You can't have a gun without a bullet. It won't work.
Right.
So when they had sold the note, monetized the note, securitized the note, whatever they did with the note, could be Alibaba and the 40 thieves who had bought the note. It could be Xing Ying Young in China who had bought the note. But I don't think they could find the doggone note for them even to foreclose or have any standing in the court.
Right.
The main issue is the validation. Show that they are the real party in interest, then you can start to talk business. Otherwise, they're not the real party in interest. They shouldn't be there as a the plaintiffs.
Okay,
am I correct?
Yes, you are, but you're talking about debtor-creditor, and I'm pulling everything out of debtor-creditor and putting it up into trust. It'd be better that I would come in and have the bank prove that they are the beneficiary.
Now, who is in control of the trust?
The trustee.
Or is the settler?
He is in control
you?
of the trust.
Sorry?
The trustee is in control of the trust.
And who is in control of the trustee?
Okay, the trustee must perform according to the expression of the indenture by the grantor. So
exactly. So if the grantor want to fire the trustee, he can fire him anytime he wants, regardless, right?
Yes, right. But the title, legal title, everything in trust res property rests with the trustee.
Right, until the grantor
to anything.
The picture, right?
Grantor has no title to anything, although he has the say-so. And he should have expressed it. And if he didn't express it, it's being construed. And how do you think it's being construed? Not in your favor. So we're going to go back, we're going to re-express the trust, and we're going to pull up and make them prove the fact that they have the burden of proof. Once we make a prima facie case, that number one, a trust exists. It has all four of the elements, the intent, purpose, parties, and specific res. And we had a formation of the trust by one of the four methods, which was declaration, transfer, appointment, and contract. And then once we do that, we've made a prima facie case, and now the other party must prove otherwise.
So basically what you're doing on the other hand is just do the validation. That's what you're doing, to validate, to make sure that they have stand.
Yeah. Now when they can't prove it, then... So I'm going to go in there and I'm going to merge the titles in one entity, and when I do that, the trust terminates.
Yeah, you're right. I need to study your system a little bit more in depth before I can really make all the dots connect. But you do have a very good point. But you and I are on the same conjunction of thoughts, legally or otherwise. Yeah. And what I have done is this. I decided to use a UCC1 financial statement to claim that I am the real party in interest in this in my home, to protect it, put a lien on it, and everything else. When the attorneys for the Wachovia decided they wanted to take me to court, they had the judge, and I explained to the judge that I am the trustor, and I'm also the settler. I have a full control of the trust. They both are no longer in existence. The attorneys for Wachovia decided to argue that they are, in fact, what we have done was fraudulent. Couldn't prove any fraud. Right now I'm in the courts of appeals. But they use tricks, and they use the judges basically as one of your enemies as well. They are not with the people in the sense of saying, let's talk about law. They drag you into the equitable law and deny your constitutional rights, deny your total rights, and you are a defendant, so therefore you're a debtor. And a debtor always lose before the court.
And why?
And the judge is only there for the system.
That?
Sorry?
Why is it they can do that? Why is it they're doing that? There's a reason why.
Well, one is that they are...
the trust.
You didn't express the trust.
That's right.
You put yourself right back
you may help.
Debtor-creditor as a debtor, obligated to a contract. You didn't make a payment on it as trustee, and you never knew you were trustee, and you're not claiming that you are a trustee or that any other party exists because you're not expressing the trust.
What do you mean by that?
See, the trust is the 900-pound gorilla that will pin you to the floor in 10 seconds. But you're not expressing trust. They're putting the gorilla suit on, and they're pinning you in 10 seconds.
So how would you apply this to the IRS rather than mortgage?
Same principle. You know, they're trying to gain access to this trust, and now there's going to be three parties. There's got to be a grantor, a trustee, and a beneficiary on this. All you have to do is identify the parties, make sure that you got the elements in there, and you have a valid trust formation, one of the methods, that the law can recognize that a trust was formed, and now it's up to them to prove otherwise, because they've got the burden of proof to prove that it was not formed. And how are they going to do that if you got the evidence? David didn't make those claims. Now they got to come up with evidence to rebut your. See, what you've done is you just reversed it on them.
What happens if the bank, if you assign the bank the trustee to terminate and they don't accept the trustee appointment?
Okay. Remember that example I said? The judge is going to say, I disclaim the appointment.
Right.
At that moment, a resulting trust forms, and now the judge under equity can't allow a trust to fail for a lack of trustee. He must appoint a new successor trustee. That's his duty under equity. If he doesn't do that, now
if they don't accept.
Yeah, he's in breach.
If they don't accept that bank, we have to take them into court to make the judge assign a trustee?
Yeah, you may have to do enforcement on the bank, take them to court. Yeah.
Okay.
Yeah, I don't expect the banks to roll over and play dead. You're going to have to do enforcement.
Yeah, you're right about that. When you go to closing, you sign the deed of trust, assigning the debtor as the beneficiary.
Right. But under what action will we bring the bank in?
They're
not a trustee because they won't accept the trustee appointment.
What we have to do is just go on ahead and make the proper papers to suspend or discharge or substitute a trustee with your name on as a trustee, you the settler or the grantor, and then file it with the Register of Deeds and have that bona fide before the court that you are indeed had fired them and cancel your signatures to the contract.
Yeah, revoke the signatures on the powers of attorney and then do the reappointment.
Everything. You're right, everything.